Burglary of a motor vehicle. What is it? What does the state of Texas have to prove on a burglary of a motor vehicle case? Hi, I'm Jeff Hampton with the Fulgham Law Firm. Welcome to our YouTube channel. Today I want to break down everything you need to know about the crime of burglary of a motor vehicle. What does the state of Texas have to prove? Are there some legal defenses that you can stand upon, particularly if you are innocent and you or a loved one has been charged with this crime in the North Texas area? And by the way, if you wait around till the end of this video, I'll also give you a free ebook, What to Do If You Have Been Charged with a Crime in Texas. All right, let's talk about this for a second. Now, in order to understand what the crime of burglary of a motor vehicle is and what has to be proven, we have to look at the Texas Penal Code. So you're going to want to look at Texas Penal Code section 30.04, and the code specifically says that a person commits the offense of burglary of a vehicle if the person, without the effective consent of the owner, breaks into or enters a vehicle or any part of a vehicle with intent to commit any felony or theft. Now, under the Texas Penal Code, what does it mean to enter? That word enter into. The word enter means to intrude any part of the body or any physical object connected with the body. All right, so you don't have to physically be all the way in the car. All right, but if you enter something, even if it's let's say you're using a hanger trying to get through and you open up and the intent is to get in there and commit theft, that can be used as an example of having the intent to commit a crime, entering into a vehicle, okay? Now, let me just go through some common questions. I think I'm gonna do this video in a little bit different way. We're gonna examine some common questions that people ask about the crime of burglary of a motor vehicle. The first one is it possible to be arrested for burglary of a vehicle when you didn't steal anything at all? Unfortunately, the answer is yes. Texas law does not require that anything be actually stolen in order to be arrested and convicted for burglary of a motor vehicle. Here's the big key, if the prosecutor can prove beyond a reasonable doubt that the accused had the criminal intent to enter the vehicle to commit a theft. Now look, it makes sense, right? There's no theft that has to be proven, but if the intent was to get in there and commit the theft, then you can still be charged with the same crime. Okay, that's burglary of a motor vehicle. Now, for example, a police officer pulls up on someone sitting in a car, digging through the center console and looking through their belongings. The officer learns that the individual in the car did not have consent to be in the car, but nothing was actually stolen. Can the police officer arrest in this situation? Yes, they can. A police officer will believe in that situation, we've seen it many times, that they have probable cause to show that a burglary of a vehicle was taking place if the person did not have consent to be in the car and they were digging through somebody's stuff, right? So if they weren't supposed to be in the car and they're digging through things, there can be an inference that there was some intent to try to steal something within the vehicle. Now, additionally, if someone appears to be fishing a hanger into a car, I talked about this earlier, if someone's trying to fish a hanger into a car and they didn't actually make it into the car, but they got the hanger in the car, that could be enough to establish probable cause for an arrest as well. Question 2, can someone be arrested for burglary of a motor vehicle when they never entered the vehicle? Technically, yes. As I defined earlier, the definition of enter can include any object connected with the body entering the vehicle. If someone were to break a window or force something through a window or through even an open window, right? Let's say the window's down, the window's rolled down. Someone's reaching into a car or getting real close into the vehicle, and their intention was to commit theft, the definition of burglary of a motor vehicle would be met under Texas criminal law. Now, here's the next question. Is burglary of a motor vehicle a felony in Texas? For a first-time offender, no, it is not. It is not under Texas law. For a first-time criminal offense of burglary of a motor vehicle, you would be charged with a Class A misdemeanor punishable by up to 1 year in the county jail and up to a $4,000 fine. However, if it is proven at a jury trial that the accused had 2 or more burglary of a motor vehicle convictions, or in other words, if you've had repeat instances of burglary of a motor vehicle, it can become more serious. It doesn't always have to be a misdemeanor charge, and you can end up facing a felony level punishment punishment range, okay? Now, let's talk about some legal defenses. Let's talk for a few minutes about legal defenses to the crime of burglary of a motor vehicle. Now, number one, in order to prove, remember, and this is somewhat kind of obvious, but I think it's good to go back and remember this. In order to prove the crime of burglary of a motor vehicle, the prosecutor will always be required to prove the element of intent beyond a reasonable doubt. If the accused had entered into someone's vehicle without their consent, the police and the prosecutor must point to some specific evidence establishing that individual's criminal intent. Merely being in the vehicle without doing anything else, merely being present in the vehicle alone, maybe you're trespassing in their vehicle, but merely being present by itself does not constitute the crime of burglary of a motor vehicle. Now, how does the police and prosecutor establish criminal intent? The most common way for the police officer specifically to establish criminal intent is to question you about the incident. If you or a loved one has gone through this and you're in someone else's car and they don't know what's going on, the number one thing that officer is going to do is start asking you questions. And if that police officer can start getting you to open up and talk to them, they can then take your words and many times fashion them into probable cause. Think about it. If you admit that you were in someone else's car and you don't have a good enough answer as to why, or you get nervous, maybe you don't feel comfortable answering the questions, the police officer will state in the report something along the lines that you appeared flustered and guilty due to a lack of a sufficient explanation for being in the vehicle. Remember, I want to remind you, you always have a right to remain silent. You do not have to answer questions when a police officer is trying to interrogate you. So I want to remind you, now look, they can look for other evidence establishing probable cause as well. But the number one way every officer, every detective tries to establish probable cause to get someone arrested is to have them talk. See if they can get them to admit something to them. See if they can get them to start talking. And then things can be kind of fashioned however they want, depending upon the statements that are given. Now, what about defense number two? Okay, number one is lack of criminal intent. Number two is consent of the owner. Now, this may seem obvious, but if you've previously received consent to enter into the vehicle, and it was reasonable for you to believe that you had consent to enter into that vehicle again, the prosecutor might not be able to prove the criminal intent element of burglary of a motor vehicle. So think about all the instances of times where you've maybe been given permission to enter into someone else's property in the past. Particularly if you entered into that vehicle and there was nothing being taken, but the officer just inferred that. Being able to show that you had previously been given consent to enter into the vehicle can make a very big difference, okay? Well, finally, what about number three? What if you did not enter into the vehicle at all? An essential element of the crime of burglary of a motor vehicle is that you must have actually entered the vehicle as defined by the law. And as discussed earlier, we defined what this is. To enter means to intrude any part of the body or any physical object connected with the body into the vehicle. So it's common, though, for many police officers to see what they believe is suspicious activity. This happens all the time. Police officers will see something, they'll say, oh, I think this guy's about to commit this crime. It's suspicious. And they may jump the gun and arrest somebody for burglary of a motor vehicle when it hasn't actually taken place. For example, what if the police officer approaches a parking lot and sees someone standing by a car, walking around it and looking inside the windows? Additionally, what if the person is pulling on the door handle or touching the windows? And obviously, a police officer is going to deem this conduct to be very suspicious and will approach them. However, it's very important to understand, without any specific evidence of the individual intruding any part of their body into that vehicle, there is no crime of burglary of a motor vehicle. Now, there may be this is where people will ask the question, okay, well, if there was no crime of burglary, could there be the crime of attempted burglary of a motor vehicle? And I wasn't going to really get into this in this video, but an attempted burglary of a motor vehicle essentially means that there was actually steps, particular motions and activities taken in order to attempt that, to effectuate it, but that it was cut short. That's very hard to prove. An attempted charge can be very difficult to prove, but more importantly, that's not enough to prove burglary of a motor vehicle, okay? Now listen, the question is, can a burglary of a motor vehicle case be dismissed? Well, number one, it can be dismissed if the state of Texas cannot meet their burden of proof. If the evidence is not sufficient to establish not just probable cause, but reasonable doubt that a crime took place, your case should be dismissed. But number two, sometimes when a good criminal defense attorney gets a hold of a case like this, they can get in there and be able to establish what's called a conditional dismissal. Sometimes on first-time offenders, there can be an agreement that if you complete certain conditions, maybe community service, maybe some sort of theft-based class, some sort of donation, different types of options, that can result in a dismissal that then makes you eligible to receive an expunction to clear your criminal record. Finally, you always have the right to a jury trial. You always have the right to go in, basically with no burden on your own. You have the right to hold the state of Texas to their burden of proof. And if 6 jurors cannot unanimously believe that you committed the crime of burglary of a motor vehicle, you would be exonerated. Now listen, I've gone over some of these things for you here today, but if you or a loved one are facing a burglary of a motor vehicle charge in the North Texas, maybe the Fort Worth, the Dallas area, I want to encourage you to give our office a call at the Fulgham Law Firm. You've seen this number up here on top of me for the last 10 minutes that I've been talking. I want to encourage you to contact that number, ask to speak to one of our attorneys. We'll be happy to give you a free case analysis and a consultation and see if we can help you out in your situation. And I promised you a free ebook. I want to thank you for waiting around to the end of this video. If you'll click the link down below, I'll email you over what to do if you have been charged with a crime in Texas. All right, I want to thank you. If this video has helped you in any way, subscribe to our YouTube channel, like this video, share it with others. We look forward to seeing you on our next video series.